Good morning, Commissioners. Roll call, District 1. District 2.
Present.
District 3.
Present.
District 4, vacant. District 5, Chair Shadid.
Present.
District 6.
Present.
District 7, vacant. District 8.
Present.
District 9.
District 9 is present.
District 10.
Present.
District 11.
Present.
District 12.
Present.
District 13.
Present.
District 14. And place 15.
I'm here.
You have quorum, sir.
Thank you very much, Ms. Pacina. In fact, we do have a quorum. Good morning, ladies and gentlemen. Today is Thursday, 11:03 a.m., December 8th, 2022. Welcome to the briefing of the Dallas City Plan Commission. Commissioners, only one item on the agenda today. We're going to start a little bit off out of order. We have some moving parts with staff. And in fact, we're going to begin with Mr. Burgess, who I think is here and ready to go. We'll have some comments and is available for questions. Good morning, Mr. Burgess.
Good morning. Yeah, I did want to give just a really quick statement because there's been some questions that have come in over the last couple of weeks since the last time we all talked, and just wanted to make sure everybody is on the same page. So one of the main questions that's come in has been whether operation of a short-term rental in a single-family residence is legal under code provisions. And the answer is that it really depends on a variety of factors, including whether the short-term rental has consistently complied with the definition of a single-family use in the Dallas Development Code. So I'm going to go through that definition, and you actually get a couple deep in there to really get the definition. But in section 51A-4.209 is where a single-family use is defined, and that is one dwelling unit on a lot. If you look at the definition for dwelling unit, that's in 51A 2.102, says it's one or more rooms to be designed as a single housekeeping unit to accommodate one family and containing one or more kitchens, one or more bathrooms, or one or more bedrooms. Then you take another step, look at the definition of family in 51A, it's 2.102, and that's individuals living together as a single housekeeping unit in which not more than 4 individuals are unrelated to the head of the household by blood, marriage, or adoption. So just a few examples. If you have a short-term rental that's consistently rented out to, say, like mom, dad, and 2 kids, that would meet the current definition of single family because it's a family living together as a single housekeeping unit. There's nothing in the code that talks about length of the rental or anything like that. On the other hand, if you have a short-term rental that's rented out to, say, other groups at times, so for example, if there was like a group of college friends coming into town for a reunion, you got 6 of them that rent out a place, they're not related to each other, that wouldn't meet the definition of single family because the dwelling unit's rented out to more than 4 individuals who are unrelated to the head of the household. And another example would be like a party house. That's one that clearly doesn't meet the definition of single family because it's not being rented out really as a dwelling unit, as a housekeeping unit. It might be a commercial amusement inside, but it would not be single family. And we've also got some questions on if future zoning regulations will cause an existing short-term rental to be a non-conforming use. And again, that's really up to the building official to make that determination. But in the code, a non-conforming use is a use that does not conform to the regulations of the Dallas Development Code, but was lawfully established under the regulations in force at the beginning of operation that had been a regular use since that time. So the building official would be looking at, yeah, was it lawfully established? You know, maybe was it single family? Has it been consistently operated that way? And that would probably be a case-by-case determination. But again, that would be up to the building official to make that. So I hope that clarified things and maybe give some clarity as to why a code amendment needs to be done, because I think even if we do nothing, I think there would still be that ambiguity of whether they comply or not, so.
Questions? Commissioner Treadway, please.
Hi, good morning. So can you confirm that the basic rule is that if a land use is not specifically allowed by the development code, then it is not considered to be a permitted use?
That's correct.
Okay. And then where is long-term rental use allowed?
So zoning-wise, we do not get into any sort of length of rental, so.
So long-term rental is not addressed by the development code?
Not at all, no.
Okay. So it's not a zoning issue?
That's not a zoning issue, yeah.
And let me start off by saying I'm new, so I read all of the emails. I have read almost everything that I have been given, and it is a lot of information. So I'm just trying to ask some clarification questions so that in my own head, I get it right. So if some of these questions seem really basic, sorry, but I am really new to all of this, and just trying to sort of sort out what is not, in my opinion, like a super clear way to analyze things. So apologies to other commissioners if you've already heard all of these questions answered. We may be a little bit repetitive.
Not at all. Fire away, please.
Okay, here I go. So long-term rental use, not a zoning issue. It is I'm assuming then a regulation issue. There's some other part of the code that deals with that?
Correct, yeah, so, length of rental, that's not regulated by zoning at all.
Okay, so there was a lot of conversation about a commercial use not permitted in a residentially zoned area. What's behind all that? Like, is there something in the development code that says you can't have a commercial use in a single family home?
I would say that's the policy issue you guys are being asked to look at, whether short-term rentals are commercial and whether they should be permitted.
Okay.
In certain areas.
But my question is there already commercial activity happening in residential areas? I'm putting aside short-term rentals, but like, just hypothetically, someone teaches swimming lessons and uses their pool that is at their single-family home. Is that considered a commercial use? And if so, how is it currently allowed under Dallas code?
So you can have home occupation as an accessory use. So that could be something maybe like a swimming lesson, or if you have a home office, something like that. Another type, I guess, of maybe commercial type use that is allowed in some single family areas could think of would be maybe a daycare center. But yeah, there's not really much that is allowed.
Okay, so this whole Board of Adjustment process, my understanding is that you go to the Board of Adjustment and you ask for an exception to the current code. So could someone, for example, have a garage apartment that has been allowed by the Board of Adjustments? Is that how that process would work for stuff that's already existing?
So the development code does allow a property owner to go to the Board of Adjustment, ask for a second dwelling unit. So kind of like a granny flat or something like that, or if you wanted to convert an apartment over your garage or something like that, there is the ability to go to the Board of Adjustment and ask for that's already built into the code.
And is that accessory or is that different?
That would be an accessory dwelling unit. So yeah, that would be accessory to the main structure.
Okay, accessory still. Okay, so let's just say there's somebody with a garage apartment that's gotten permission from the Board of Adjustment to have that. Is it a use? Like, is that what's been permitted? Sorry, and I'm going to try to avoid using that word because permit uses. Has it been allowed by the Board of Adjustments as a use, like, this garage apartment, or is it a dwelling unit? Like, I'm very confused about if what the code is doing is saying, yes, you can have a second dwelling unit, or if there's something else that says, here's how you use the second dwelling unit. Am I being clear?
Being clear, and I think we may be getting off topic here because it's,
Okay, where I want to go back to is then if we change things that have already been allowed by the Board of Adjustments, how does changing a development code provision impact that? Or can they coexist?
so as far as something that has been allowed by a Board of Adjustment, there's nothing that you guys are looking at today that I'm thinking of that would affect that. So what the board has the ability to do is allow that additional dwelling unit. Okay, whether somebody uses that as a short-term rental or something else, that wouldn't affect the ability to have that second dwelling unit. That's a land use determination you guys are coming up with. So potentially, if you guys allow the STRs, then yeah, there may be the ability to use those additional dwelling units, but that wouldn't affect the ability to have the additional dwelling unit, if that makes sense.
So I go back to have versus use. To me, I understand there's a distinction, but it seems to be something that we should be sort of evaluating. So if you can have a unit and you have a unit right now, like, does the city know how many rental units have been approved by the Board of Adjustments? Because that process isn't new.
Yeah, I would have to defer to planning on that if we have those numbers.
Because if we have this approval process that's already in place.
Sorry, so we have some slides discussing accessory uses, accessory dwelling uses, additional dwelling units. We have some of that in one of the slideshows if we want to kind of delay some of that discussion until we actually open up and get into an agenda item.
Commissioner Treadway, yes. Mr. Burgess, if you could maybe focus your questions on the legal aspect for him, and I think Mr. Goss has some of the answers to your questions coming.
Okay, then I'll go back to legal question. In your opinion, what is the precedential impact of the Fifth Circuit case? Does it apply to Texas state law, or would it just apply if something came up in a federal court?
The Fifth Circuit case, it interpreted the U.S. Constitution, so that would apply to, Fifth Circuit and Texas. Yeah, are you looking for something else other than that, or?
No, I've heard kind of different questions, but, yes, it addresses the U.S. Constitution. It addresses Louisiana law, but it also addresses the U.S. Constitution, which the Texas Supreme Court would also be required to follow.
Correct.
And it's still, to your knowledge, has the Texas Supreme Court taken up any of the cases that have come up through the appellate courts in Texas yet?
Well, there have been some in the past. So the Zatari case is one that's the big one that's out there. That was the city of Austin.
But has the Texas Supreme Court taken up
The
anything?
Supreme Court, no. But I think of any that the Supreme Court has taken up at this point. Correct.
Okay. And then, I can pause on the questions. I don't know if we're going to get into kind of, if you're the right person or somebody else, like what exactly is in this whole home sharing concept is an owner, an operator, a primary resident? Like, are these legally defined terms? Are they zone defined terms in regulation? Like, I'm not really sure sort of where that neatly fits. And Tony, I don't know if that's a question for him or somebody else.
Mr. Burgess, do you have an answer for that? No,
Yeah, and I believe that's things that would be discussed in the briefing, and if you guys want to move forward with that, those are all things that we would clarify.
Okay, I think I can pause for now, because I think some of this other stuff will get addressed. But I'm still just a little flummoxed that long-term rentals aren't addressed at all in land use code. It's only addressed by regulation.
Correct.
Thank you. Commissioner Young.
Yes, first of all, am I wrong? I thought that the Board of Adjustment in granting permission for an ADU was required to put in a condition that the owner must deed restrict it against rental?
So within the single-family residential use, there are two additional provisions. One is an additional dwelling unit. That is the non-rentable. That is the deed restriction requirement. There is also an accessory dwelling unit, which is rentable. That's the only difference between the two. Either one of those has to go to the board for an approval of a special exception. So additional is non-rentable, accessory is rentable. And then there's the opt-in neighborhood overlay process for accessory dwelling units. So that's kind of separate.
Okay. My other question is about the general accessory use provisions of the development code. Am I right that, first of all, the building official would have to find that a short-term rental was customarily incidental to a main use? In this case, the single-family use.
So if it depends on if this body and city council approves a code amendment to create home sharing as an
sure.
additional. But if we're talking about today,
I'm talking about
that's a
today.
you question. That's cool.
And the code further requires that when conducted inside, an accessory use cannot occupy more than 5% of the square footage of the main use.
Those are both correct, yeah. So if there's not a specifically defined accessory use, yeah, there would have to be a finding that the use was customarily incidental to the main use. And I know there is a percentage limitation on square footage. I'm not sure exactly what that number is off the top of my head, but I know that that is in there.
It's 5%. So to have a 300 square foot STR, I would have to have at least a 6,000 square foot house.
That's correct.
Okay, thank you.
Commissioner Sander.
Yes. Just to clarify something, we have designated in our code, correct, zoning districts and what is permitted in those. Is that correct?
Correct.
Okay. And in a single-family residential area, I heard you just say, yes, you might be able to have an occupational thing, but on the other hand, you couldn't just open a beauty salon with 6 bays with washing your hair and have customers come, correct?
No, you would not be able to
No,
do
you're
that.
not permitted by our zoning code to have commercial enterprises as opposed to swimming lessons or tutoring in your house.
Correct.
Or something that we would call a more occupational, where you don't have throngs of people coming, transients, whatever, okay? Is that correct?
That's correct.
So essentially, one could infer from the code and the way the districts are set up, and they set it out very clearly about what's permitted and what is not, that in a single-family residential district, you are not permitted presently to have a hotel, a commercial store, retail, and that there are very few commercial-type enterprises that are allowed. Is that correct?
Correct.
Okay, thank you.
Okay, I'll check it.
I think that Vice Chair Rubin and then Commissioner Blaze.
Mr. Burgess, I just wanted to understand what happens if this ordinance, as we have before us today, gets enacted by council, as it is exactly before us today, which would prohibit STRs in residential zoning districts, whether they would be single-family or multifamily. What would happen if, in setting aside the non-conforming use issue, what would happen if someone continued to operate an STR in a residential district? What is the process that the city would go through to bring that, parcel into compliance?
Yeah, so leaving the non-conforming issue aside, what would happen would be complaints came in, code would go out. At some point, they would likely issue a notice of violation. if the notice of violation wasn't complied with. The way that works is that they would give you a certain amount of time to bring your property into compliance. If you didn't comply within that amount of time, at some point, you would likely get a citation. That could be up to a $2,000 fine. And then if the citations are ignored, at some point, the city would probably take the property owner to court and seek an injunction to have the court require the use to be ceased.
Okay, so notice of compliance is step one, right?
Correct.
Then citation is step two?
Correct.
How much time is there is there a time that has to lapse between a notice of compliance and citation?
We may want to get Jeremy to address this.
Good morning, Commissioners. Jeremy Reed, Assistant Director for Code Compliance. So to your question about time elapsing between notice and citation, that's mostly an internal procedure. The goal there is what we would be eventually bringing to court at a citation level, we would be able to express that it was a reasonable time given. So anywhere between 2 weeks and 30 days, depending on if that's a reasonable time for them to either cease operation, obtain a certificate of occupancy, depending on what the remedy of the violation would be.
And there would be no ability to obtain a CO in this situation if what we have before us today is enacted, right?
Correct.
So it'd be having to cease operation. So there would be initial citation. Does that initial citation include the fine, or are those two separate steps?
Yeah, so the fine would be assessed by the courts. So, yeah, the citation, that'd be like if you get a traffic ticket. So, yeah, you could go to court, argue the citation, then the court would make a decision, and if they found you guilty, they could issue a fine.
Okay. And that's a municipal court or district? Okay. And then if the fine isn't paid, the next step is the city going to court and seeking an injunction, or is that something that can operate on a parallel track with the notice of compliance, citation, and fine?
Yeah, I would say typically, yeah, someone would just, they ignore the citations, and they just continue to operate. At some point, community prosecution will likely take them to court, but.
And is that a separate legal process in district court, or is that also in the municipal court as part of the same proceeding?
It would not be part of the municipal proceeding as far as fines and things. So we can see if we get somebody from community prosecution to come down to answer what court that would go to. Yeah, I'm not sure right off the top of my head. That's
okay. Not critical. So how long are we looking, if there is someone who is recalcitrant that operates an STR and this thing gets enacted, from, this being called into the city to getting into court to getting an injunction?
So I'll just interject real quick about the code compliance process. As a matter of procedure, because the city attorney's community prosecution team has a bandwidth, usually what we do in code compliance is write multiple citations before that referral process. So I can't speak to the final injunction time frame or getting that to the judge, but before it goes from code's initial notice to the first citation, community prosecution usually requires at least 2 or 3 citations before referring it to them for review, but it all depends on how egregious an impact that particular violation is having on the community.
And as of right now, that fine is capped at $2,000?
Correct, yeah, state law caps at $2,000.
Can those stack on top of each other? If, you operate an STR on, January 1st, then you're doing the same thing on January 2nd. Is that a separate $2,000 fine, or does that all rack into just one $2,000?
Yeah, per state law, yeah, they can stack on top of each other, so it could be $2,000 a day, so.
Okay. Thank you.
Commissioner Blake, just have one quick follow-up before I go to you. Mr. Burgess, just to make sure I understand the process. So today, when we have a problem STR, the first step is for folks to call code enforcement. Is that correct? And if we were to pass the ZARC recommendation, goes to council, it becomes the law, and there are some STRs that choose not to, in fact, close down, and they become a problem, what is their first step? They're going to call the police, or they're going to call a community prosecutor, or in fact, do they call code?
Yeah, it would likely work the same way. So, yeah, neighbors could make a complaint to 311 to go to code, that would go to code compliance. Code compliance would go out, and it would largely follow the same process.
So it's the exact same process?
Yeah, it'd be the same process. The only thing I could think of, police getting involved would be if it was, something bigger going on there. They generally wouldn't go out for a zoning violation.
Okay. Commissioner Blair.
Mr. Burgess, I want to go back to commercial use and single-family residence. And you muddied water, well, this conversation has muddied some waters for me. So are you saying that existing commercial use and existing residential units is a violation of our existing code? So in the example that we had about the beauty shop, barber shop, 6 bays, whether it's 1 bay, 6 bays in a residential property is not a valid use of land.
So if I could, under the home occupation accessory use, one could theoretically cut hair in their house for customers. It's just a matter of meeting all of the provisions in the accessory use home occupation section. The 5% rule, no advertising, cannot create any sort of undue stress for traffic or parking. There's a list of provisions, but under current code, you can cut hair in your house. It's just a matter of meeting those provisions. Could you open a 6-bay salon? Theoretically, if you could meet all the requirements, but you couldn't probably do that.
So let me go a step further. After post-COVID, we have more corporations requiring their employees to do their job and work out of their residence, opposed to coming into an office. Are we saying that is it based on the type of work that they're doing, whether they have a lot of traffic or no traffic, it's legal, so let me give you another example. I'm a trucker. I got a trucking company. I'm the logistics department, and we know trucking, warehousing, and the such is an IM use. But I'm operating a trucking company. I may park the truck somewhere else, but I'm operating a full-blown trucking company out of 5% of my house without advertising or whatever the rules are. You're saying that is a legal use of land in a residential area.
So as long as it meets all the provisions of a home occupation, which is an accessory, so it has to be primarily incidental to the residential use of the property. One of the provisions is, so home occupation may not occupy more than 25% or 400 square feet of the main structure, whichever is less. You cannot generate loud or raucous noise that renders the enjoyment of life or property uncomfortable or interferes with public peace and comfort. You can't involve more than 3 people on the premises at one time other than the residents. You can't conduct anything outside. You can't employ more than 1 person on the premises other than residents of the premises. So if you meet those requirements, then it's a home occupation.
Going back to my example, I have assistant that comes into the house Monday through Friday from 8 to 5. It's just me and that assistant. Mm-hmm. We only occupy a room, converted a bedroom into my office, my business. And I do all of those things As long as a commercial vehicle does not come up and park in front of my house, I'm good.
So a commercial vehicle parking in front of your house would be a traffic question, not really
But
related.
we get past that, but yeah.
So code section 51A 4.217 is accessory uses. Paragraph 8 is home occupation. I don't know, we're past Romanettes at this point, but E, additional provisions, Romanet 1, sub-Romanet DD, you shall not have an employee other than a resident of the premise who works on the premises more than 4 hours in any given week. So if you had a Monday through Friday employee, no. But if that person only worked 4 hours per week, yes.
Is that 4 hours per week in that location or 4 hours per week, period?
That's on the premise, who works on the premises.
So as long as they don't come into my house more than 4 hours a week, I'm good.
Correct.
Thank you.
Commissioners, if we could just limit our questions for Mr. Burgess for now. We're going to come back to Mr. Dawes because we have a presentation by Dr. Anderchek here, and she has a hard stop coming up. So if we could just for the moment limit to Mr. Burgess, and then we can get that presentation in. Commissioner Housewright, please.
Mr. Burgess, we just learned a little while ago that long-term rentals are not a zoning issue. Did I using the words right on that?
That's correct.
Okay. Is there, in your opinion, a legal precedent then for short-term rentals to become a zoning issue? Can you support that from a legal standpoint?
Yeah, I mean, we can't support the creation of a new land use, so this is something that there is some ambiguity, right, as to whether that would fall under single family or something else. So the creation of a new use for this seems to be something that is appropriate. So it's not regulating the rental as such. This would be the creation of a new use. And all the things that would go along with that is, parking requirements, things of that nature.
Okay, follow-up question?
Please.
This is a different dimension of the issue we're discussing, and it's the hot taxes, the hotel taxes. I just wanted to ask you, in a lot of the reading we're doing, we're hearing about taxes not being paid. Can you tell me what legal recourse the city has, whether these are allowed or not, whether we're a single-family neighborhood or whether we're in a mixed-use district, whatever? If they're not being paid, does the city have the ability to take some sort of action to recover those taxes? Is there an ability to put a lien on the property like you would for property taxes? Walk me through that, please.
I know that there. Kind of like we talked about earlier, if you're operating in illegal land use, how you can get a citation and get a fine for that. So you can for non-payment of the HOT as well. I know that, if we know that you're out there and you're not paying the hotel occupancy tax at some point, the city is likely to take some sort of collection action to try to recover that money.
Can it go so far as a lien on the property?
So I'm not an expert on tax law, so I don't want to give you guys the wrong answer. So, but I could see if we get one of our collections or tax people down here and get that for you.
Yes, I have a quick question, Mr. Burrs. My question is this. Does not our zoning regulations that we have in force say that in single-family residential districts there is no lodging uses permitted? Oh, Lord.
Yeah, the code in front of me, but I think that's...
So the short answer is those words are not in the code.
Well, I just saw
The words.
not permitted lodging.
So our code it says in a single family district, you can do these things. And if we don't say you can do them, then you can't do them. But there's no word that say you can't do those here, because if we don't say it, it's understood that you can't do it. So
It says lodging is not permitted.
then
Lodging
yes, it does
use
say
is not permitted. Okay,
Okay.
so if I'm reading that and it's in there and we agree that that's what it says, Lodging use not permitted in a single-family residential district.
The code section.
Okay, and we're looking at it. Then what follows is hotels are considered lodging, right?
That's correct.
And if you're paying a hotel tax, that would equate STRs, short-term rentals, to lodging. The implication would be there. If you're putting them under hotel tax and there's no lodging permitted, then hotel tax says it is lodging. So something's being done presently that is not permitted in single-family residential districts. That's a question.
So I think we're finding the code section. Do you have a specific code section? Because we're looking for it. We just want to be on the same page. But
51A 4.112
And 113, right?
E, lodging uses.
Yes, 51A 4.112. That's what we're looking at.
A1E.
Okay. As usual,
A2.
Commissioner Hampton knows more
Mr.
than
Doss,
I.
you want to take a look at that? We'll come back to it. Commissioner Treadway?
Thanks. I was wondering about the code reference for the accessory use, those elements that he was going through. Is that in 51A or is that someplace else? And we can come back to that, but my second question is, there does appear to be a residential hotel that is a permitted use in a residential area. And I was just hoping somebody could explain exactly what that covers. That's a briefing question, not a legal question? Okay, I'm happy to hold it then.
Okay. Anything else from Mr. Burgess? Vice Chair Rubin?
Yeah, just one follow-up question now that I've digested your information about community prosecution. I'm not super familiar with the, community prosecution division within the city attorney's office. I had a law school classmate that worked there a long time ago, but don't know much about it. How many attorneys are there in the community prosecution division?
Yeah, actually, I don't have a number right off the top of my head. I know there are several of them, though. I know that there are different attorneys that are assigned to different council districts. But yeah, as far as a total number, I don't know that.
And do you have a sense of, I know there are a lot of variables here, but if, if this ordinance that we have were adopted as it is today, prohibiting STRs and single-family and multifamily districts were adopted, would there be a need for additional FTEs within community prosecution to enforce that? Do you have a sense, or do they have excess capacity? Or I know we don't know how many recalcitrant owners there would be, but we hear a lot of anecdotal stories about, operators who cause problems, so I would think that might be an issue. Do you have a sense of whether there would need to be additional FTEs in community prosecution?
Yeah, unfortunately, I have no sense on that one, whether we would need to bring in additional people or not.
Okay, great, thanks.
One very last quick little follow-up, Mr. Burgess, just to maybe clear up some confusion that may have happened at ZOAC. Did the Fifth Circuit decision make the home sharing option not viable?
So I think they left the door open.
Okay.
That case involved the city of New Orleans, and New Orleans had an owner occupancy provision in their code. And in their argument, the city of New Orleans brought up a case in the Ninth Circuit that involved the city of Santa Monica that had a home sharing model. And they said, well, hey, the Ninth Circuit allowed this. In the New Orleans case, the court basically said, yeah, we know about that. That's a different situation. And they kind of left it at that. So they didn't really say that they disagreed with the Ninth Circuit, and they didn't really say that that wasn't allowed. So I think they left the door open. If that's something you guys are interested in, we can certainly explore that. It would need some fleshing out to make sure, everything's legal and enforceable, but yeah, we could definitely look at it.
Okay. Vice Chair Rubin.
Didn't the Fifth Circuit give an example in that case of a way to do something similar to what New Orleans was doing without it depending on the residency or citizenship of the owner?
Yeah, I don't remember all the details, but it seems like they did give an example or two. That is correct.
And that's separate and apart from their discussion of the Ninth Circuit case?
Correct.
Okay.
Commissioner Kingston, please.
Thank you. Mr. Burgess, the Ninth Circuit opinion, or the Ninth Circuit law doesn't apply in the Fifth Circuit, correct?
Correct.
And is it also correct that there is no case that governs Texas that allows for home sharing should we evaluate adopting that?
Yeah, there's nothing really out there one way or the other than the New Orleans case. And yeah, it mentioned the Ninth Circuit case in a footnote.
Okay, that's it.
That's it.
All
Yeah,
right.
that's all there is.
Thank you.
Thank you. Any other questions for Mr. Burgess, commissioners? Okay, thank you very much, sir.
You're welcome.
Dr. Anderchek, good morning. Commissioners, we're going to have a quick briefing, and we appreciate Dr. Anderchek being here on her day off. Thank you so much. The mic is off, yeah.
Good morning,
Good morning.
Chair Shadid, Vice Chair Rubin, members of the Commission. Thank you very much for having us today. We are glad to be here. Thank you for your flexibility as we make our schedules work. So we are here to share with you the recent update to the short-term rental analysis. There was a memo that was sent out to the City Council on November 10th, and it was an update of an initial analysis that was done in the early spring of 2021. And I just wanted to talk for just a second about how this all started, which I know many of you know because you've probably been involved in this discussion for that long. Initially, we were asked, our team, so I should, please forgive me. So my name is Dr. Britta Anderchek, and I serve as the Chief Data Officer for the city, as well as the Director of the Office of Data Analytics and Business Intelligence. I left out that critical bit of information. So my office, Data Analytics and Business Intelligence, was asked to take a look at this and say, we are hearing that we are seeing nuisance STRs. We're hearing this from neighbors. We want to know, is this widespread, or is this just something that is isolated to those properties that we're hearing about? And so this analysis was our best attempt to answer that question, to take a look at the data, the best data we had available, and sort of try to piece that apart to give you all a sense of a data foundation for the discussion and the decision that you're making. There is no policy recommendation in this paper, and so before we take questions, we're just going to have a brief presentation to walk you through what we did and to let you know about some publicly available resources that you all can take a look at as well. So I'm going to invite Dr. Malini Banerjee and Mr. Joseph Kerr, both from the office, to present this updated analysis. Dr. Banerjee.
Thank you, Dr. Anderchek. A very good morning to everyone. Next slide, please. This presentation is divided in 4 parts: background, history, data and methods, results, and conclusion. As Dr. Anderchek mentioned, we are presenting you an update of the initial analysis that we did in May of 2021. So this is just the updated part of it. We published this analysis first time on May 3rd, 2021. A memo was sent out, and I'm going to be referring to this paper as the original version or the first version of the analysis, because today we are just talking about the update made to that original version. In the original paper, we looked into 4 different questions. The first one was, do STR properties generate more nuisance calls to our 911 and 311 system compared to non-STR properties? Impact of STR properties on property tax appraisal values, impact of STRs on affordable housing stock within the city, and ownership of STR properties. Both these memos and papers are available online on the STR homepage. I've included URLs here. If you have any challenge accessing that, please let us know. We are more than happy to share with you the papers we've written. Next slide, please. A few months ago, our city manager, Mr. Broadnax, approached us and tasked us with updating one of the impact analysis from the original paper. He wanted us to redo the part that looks at nuisance calls generated by STRs versus non-STRs using a more recent data. The data that we used for this update was from March of 2021 through March of 2022. Aside from this new data set, methods, any data analysis techniques, data presentation techniques, all of them were exactly the same as the original paper. Next slide, please. As I mentioned, we collected our 911 and 311 nuisance call data from CAD and CRM systems. Residential data was collected from tax appraisal district data from Dallas County, Collin and Denton County. Registered and possible STR address data was collected from MuniRevs. We do understand that every data set comes with their limitation. And the reason we went with MuniRevs was this was the only data set that we had available to us where we could verify property address and validate it. Within the new 311 call types, parking violations, 24-hour parking violations, litter removal requests, chronic noise complaints, sanitation litter cans were the call types that were considered as nuisance call types. In this recent update, we were also able to include a new service request type that was added on the 311 system, which is related to STR. There were about, I think, 60 plus calls in there. For 911 system, we included loud music, disturbance, and parking violation as nuisance call types. Next slide, please. Regarding methodology, again, as I mentioned, the methodology we used is exactly the same as was used in the original paper. What we did was we looked at the STR addresses and tried to match it with the addresses that were coming in through our 911 and 311 nuisance call tables. If there was a direct match, we considered it an STR call. Whenever there wasn't a match, it was considered a non-STR call. I just want to point out that we made an assumption here that if a property was identified as STR, it was being operated as STR during the time when the call was generated. This could lead to a little bit of overestimation of STR calls in our calculation, but we were trying to be conservative and considered maximum impact to our neighborhoods. Once we divided the STR and non-STR call groups, we conducted further statistical analysis, which we will present in the following slides. And again, I repeat, the methodology, data analysis presentation in this updated version remains exactly the same as the original version. I would request our senior data science analyst, Joseph Kerr, to present the result in analysis version of it. Thanks.
Thank you, Dr. Banerjee, and thank you, Dr. Andrzejczyk, and members of the commission. As Dr. Banerjee stated, I will share some of the more granular details from the analysis that our office performed. So the city employs the vendor MuniRevs to identify and register short-term rental properties throughout the city of Dallas. The data collected from MuniRevs was used as the authoritative data source, where we specifically focused on two property registration types. Those that are identified as active, and so those properties are actively registered with the city of Dallas and they are paying appropriate city taxes. And then property types that are identified by MuniRevs as possible short-term rentals. However, these properties are not registered with the city and therefore not paying appropriate taxes. So in our analysis, we identified 1,439 short-term rental properties that are actively registered with the city, and 1,189 properties that are not currently registered with the city and identified as possible short-term rentals, for a total amount of 2,628 short-term rental properties. Excuse me. If you look to the visualization on the right, you can see the spatial distribution of short-term rental properties throughout the city of Dallas. The green dots in the map represent the active and registered properties, and the red dots represent the possible short-term rental properties identified in MuniRevs data tables. Next slide, please. Our next step was to collect data from both the 311 and 911 call centers from the time period of March of 2021 to March of 2022. And we had specifically focused on nuisance calls that were previously identified and recommended by the Short-Term Rental Task Force. And those nuisance calls included, like Dr. Banerjee previously presented, parking violations, litter and sanitation removal requests, noise complaints, and then a new service request type in the 311 call center, which is specifically related to short-term rentals and short-term rental complaints. For the 911 call data, we identified parking violations as well as loud music disturbances. Our analysis identified that parking violations constituted the most frequent 311 service request type that were related to short-term rentals, and loud music disturbances constituted the most frequent 911 call type. If we take a closer look, sorry, next slide, please. If we take a closer look at the frequencies of calls that are related to specific properties, that is making a comparison between short-term rentals and non-short-term rentals, we can see that on average, and out of about 170 short-term rental properties, the total number or the average number of calls in a 1 calendar year period was about 2. Similarly, for non-short-term rental properties, out of a total of 10,546, the average number of calls received to the 311 call center in a 1 calendar year period was just over 1.5. For the 911 call data, we can see a similar trend for short-term rental properties, where out of 155 distinct properties, the average number of calls in 1 calendar year received by 911 was about 3. And for non-short-term rentals, out of about 5,800 properties, the average number of calls in a 1 calendar year period was about 1.9 or 2. If we take the difference of these averages, we can see that short-term rental properties equates to about 1 additional call per year. Next slide, please. So if we specifically look at the distribution of the number of calls received by both short-term rentals and non-short-term rentals, we can see that the majority of properties only receive about 1 call to either 311 or 911. So if we look at the visualization on the right, if you specifically look at the taller bars on the left-hand side of each panel, that would represent the properties, the number of properties that receive only 1 call per year. The properties that received 2 or more calls per year were identified as out of the ordinary or outliers in our study, because they only represent about 4.6% or 123 specific properties out of the total number of short-term rentals analyzed in this analysis. In addition to providing an update to Impact Analysis 1, our office, in close consultation with our Geographic Information System team members, have provided an updated and interactive mapping application that depicts the 311 and 911 calls related to short-term rentals throughout the city. I invite you to please visit and use this application by following the provided link on the slide. I'm now going to pass it to Dr. Andrzejczyk to summarize our study findings and conclusions. Thank you.
So some quick conclusions for you here in our last slide. There were 2,600 STRs that were utilized in this analysis that came from MuniRevs. MuniRevs had addresses which no other source had to offer us. And without addresses, we cannot match them to the nuisance calls. STRs represented less than 1% of the city's overall housing stock at this 2,600 number. And of the 57,000 nuisance calls, just over 800 were attributed to STR properties using this geolocation. Over 88% of STRs generated 0 311 or 911 calls. And in general, STRs generated about 1 additional call per year compared to non-STRs. 123 or almost 5% of the STR properties generated 2 or more 311 or 911 calls. And most properties in general in the sample, both STRs and non-STRs, generated 1 or less call for service overall. Thank you very much for your time. I hope that this was helpful, and we are available to answer any questions that you may have.
Thank you very much for the briefing. Questions, Commissioner Treadway.
Thank you. Very interesting. Just two quick questions. Do you have any data on, calls from long-term rentals? I mean, is that information that you had otherwise?
No, and I don't know how I would get that. I don't know if we have a way to figure out which properties are long-term rentals.
Okay. And then my second question is, again, I've read a lot of information recently. There seemed to be a figure that a lot of the emails were citing that there were 6,000 STRs. Do you know where that number would have come from? Because it was repeated over and over again, but I don't know what the source was.
My understanding is there are some non-MuniRev sources that have higher estimates of STRs in the city of Dallas.
But, I mean, I thought you were very thorough. I mean, I read the report, I read both of them, and, the analysis of why you used the system you did to identify, clearly you believe that this number is an accurate reflection of STRs, more so than the 6,000 number?
So what we have, the official data source for the city of Dallas is the MuniRev system, and that system has addresses. So it is the best data we have available. We have not identified any other data source, even those that are publicly available, that has addresses for us to do this matching with. So my assessment professionally is that the 2,600 seems probably close. And even if it wasn't, even if the number was higher, 2,600 is a pretty robust sample to get a sense of what is happening from a statistical point of view. And that doesn't mean that people that are living near a nuisance property are not having a very different experience, and I want to be clear about that. But what it means is that experience, we were unable to find that was generalizable to the overall sample.
Okay, thank you.
Thank you, Commissioner Kingston.
Thank you. First, I'd like to apologize for calling you in on your vacation. Thank you for coming down. So my understanding, and I'll just pick up with the topic that Commissioner Treadway was asking about, there are at least 3 other data sources for the number of STRs in a particular area, including AirD&E, Inside Airbnb, and Host Compliance, and all 3 of those are used by other cities. Isn't that correct?
I do not know what other cities use.
And all 3 of those cite approximately twice as many or more STRs in the city of Dallas than MuniRevs, right?
I don't know. The only one that we've looked at was Inside Airbnb.
Okay. And speaking of what you were asked to look at, City Manager Broadnax asked you to evaluate, to limit your analysis to nuisance calls, right?
So the initial analysis about nuisance calls came from the initial STR task force that was formed in late 2020, and there were appointed members on that from council members.
Well, I heard one of you say, and I don't know if it was you or I apologize, I've missed your name.
Dr. Banerjee.
Thank you. Say that this updated memo was requested by Mr. Broadnax, and the scope of it was defined as nuisance calls.
So there were 4 analyses in the initial paper, and the impact analysis 1 was around the nuisance calls, and there was a request to update that with current data, since the data was about 1.5 years old at that point.
Okay, so your recent memo dated November 10th, 2022 is focused on 2 types of 911 calls, that being priority 4 calls for loud music and priority 4 calls for parking violation, correct?
It includes the whole listing of 311 and 911 calls that we reviewed in the paper. So there's some litter, there's some noise, there's some music, and there's calls from both 311 and 911 systems.
Correct, but it doesn't include priority 1, priority 2, priority 3, 911 calls, right?
No, ma'am.
Right, so murders, drug, sexual assault, any of those type, guns, any of those type of complaints would not be included in your analysis, right?
Correct.
All right. Thank you.
Thank you. Commissioner Hawk?
Hi there, a couple of questions. On slide 6,
I can't hear her.
Commissioner Hawk, you're very faint. If you could maybe speak up a little bit or get a little closer to the microphone, please.
Sure, can you hear me now?
A little bit better, yes.
Okay, let me try getting a little closer. So on slide 6, possible STRs, what criteria is used to determine that definition?
Give me one moment to join you on slide 6. This is the data that is coming directly from the city's vendor, MuniRevs. And so we are taking from them what they identify as active.
Okay, my question was around possible, and I see here it's identified as possible, but we don't know that. Like, what criteria do they use to say, oh, this is a possible STR? Because they're not registered.
Understood. I do not know the answer to that question.
Okay. And then could you just go back to slide 8? I'd like to see those inputs on the table again. Okay, thank you. Okay, that's all I have. Thank you very much.
Thank you. Commissioner Stanton.
Yes, and thank you for your analysis. And I understand that you are statisticians, and I had to take statistics back in school. But here is my question, and I'm not sure how to pose it, but when you're looking at 311 and 911 calls, and I understand you're looking at numbers, you're looking at one source, MuniRevs, because we contract with them, and even though there might be other sources. But here's what I'm asking, from a statistical standpoint, do you have factor in anything that says that people don't tend to call in about, for instance, like I know that you have to be above 56 decibels to have a noise thing. Well, I've got no monitor. And noise can be noise that's irritating, but you understand on a Saturday night calling 311 and registering a complaint is pretty meaningless. So I'm looking at real life things. So that you wouldn't catch nuisances that are occurring. And the same about 911. Obviously, I'm not going to call up the police because I don't like how many cars are in my neighborhood and I can barely pull out and see to get on the street. But that's a practical matter. I also have nowhere to go with the fact that my 6-year-old cannot play outside because they're transients all the time at this house. So my question is, how do you factor in things that don't show up when you're presenting an analysis? And I know that's very difficult. I'm asking a very difficult question, but if you can address that, I'd appreciate it.
I appreciate your question, and you are right. This is one of the limitations in doing any data analysis, is that if somebody doesn't pick up the phone and call, there's not a way for us to count that call and attribute it. And so you're right, there may be times when people do not pick up the phone and call, even though they're experiencing a problem, but we don't have a way to work with that data if that call never happens. And so that is one of those things that we acknowledge in the limitation section. We say, we're working with what we have. We're doing the best job we can with the best data we can get our hands on. But we're not going to capture everything. We're not going to capture your irritation that you can barely drive down the street, which is understandable. And so that is just one of the limitations, and that's where the stories from the neighbors and people have to fill in that piece.
And I guess that's what I'm saying, although I'm glad you did this and I know that our city manager requested it, I'm just not quite sure I see how useful maybe it is in the discussion of the subject, but thank you for your thorough analysis.
Thank you.
Commissioner Housewright.
Thank you, Mr. Chair. I never really trust my math, and so I'm going to ask you to help me with the math. But if we're at 0.09% of residences are STRs, that would suggest that the pool of residences that you're looking at is about 300,000. Is that, my math right on that?
I'm seeing that, yes, your math is right on
good.
that.
All right, so I got that right. I read time and time again in these emails we've been receiving that there's 500,000 residences in the city. Any comment on that one way or the other?
Yes, I think, and someone is welcome to correct me if I'm wrong, that we're using residential parcels from DCAT, is that correct? So the residences in question may be in commercial properties, which apartments are considered commercial properties, so there are certainly housing there, but they would not be included in the residential parcels that we were using.
Okay, so your number is then confined to single-family residences, 300?
Yes. So that was yes.
Okay, that's helpful. And then my next question, I think has an obvious answer, but I'd just like to ask it because I receive a lot of emails from constituents in my district that talk about placing 311 calls and yet there's no response, there's no help, there's no whatever. Your data here, when you're counting these calls, it's just a call, it's not a response, it's a call is captured in this data.
That's correct.
Okay, thank you.
Commissioner Young.
Yes. Do I understand correctly, you used the MuniRev's data because it was the only data that had addresses and you needed addresses in order to match the calls to it?
Yes, sir.
Not necessarily based on a judgment that it was the most reliable data?
It had the attribute that we needed, which was addresses, to do the analysis we were asked to do. And it is the city's official source.
All right, but those were the sole reasons you chose that rather than one of the other data sets?
There are no addresses in the other data sets that we looked at.
That's what I'm asking. The reason you chose that one was for those two reasons. It was the official city vendor and it had addresses.
Yes, sir.
All right. If, in fact, the other data sets are accurate and show larger numbers of STRs, then I want to focus on those that would be in those larger data sets but not in the MuniRev data set. Am I correct? Your analysis assigned those units to the non-STR category.
So let me just repeat your question to make sure I'm understanding you. So what you're saying is if the data set that we have from UniRevs, if a larger number is correct and those addresses still exist in the city, that delta, in our analysis, they would be in the non-STR addresses. Is that what you're asking?
That's my question.
Yes, sir, that is correct.
Okay, you assumed anybody that wasn't in MuniRev was a non-STR.
Yes.
And any calls associated with those non-MuniRev addresses that out in the real world turn out to be STRs, those were lumped in with the non-STR calls?
Yes.
Okay. Next question, and this follows up on Commissioner Stannard's questions. You're dealing with data, and the data that you have is 311 and 911. We don't have any data source for the number of loud parties or parked cars or people patrolling the alleys or any other nuisances that don't show up in a 311 or 911 call. Is that correct?
Not to my knowledge.
Okay. Are you familiar with, well, first of all, are you familiar with whether code enforcement has nighttime response?
I do not know about code enforcement's operations.
Okay. And are you aware that 911 police response for level 4 calls averages 9.5 hours?
I am not aware of the operational time of 911 call response.
Okay, so the same would be true of priority 3 calls, which are like 5 hours and 15 minutes.
Yes.
Okay. So are you also familiar with the fact that code enforcement generally requires that they see a violation with their own eyes before they will issue a warning or citation?
That might be a question for Assistant Director Reed.
Okay, well, I'll probably ask him later on. But if that's right, then would you expect that either, whether the people making a 311 call only to be told however many days later that no violation was observed so nothing can be done, or a person making a 911 call and getting a police response 9.5 hours later, again saying, well, sorry ma'am, but I didn't see anything happen, so I can't do anything. would you expect that those people would quickly learn that 311 and 911 calls were not an effective means of addressing a nuisance complaint?
Well, I think you have some answers from behind me. So I'm not here to speak about human behavior. I certainly understand what you're saying. And we get millions and millions of calls to both 911 and 311.
Right, but we don't know how, to borrow from Donald Rumsfeld, we don't know the unknown unknowns. We don't know how many are out there that didn't result in those calls.
Absolutely. We do not know who didn't call.
Okay, the third set of questions is about this slide that's on the screen right now. When I first looked at this and I saw 1.89 non-STR average calls per property, 911 calls, I thought to myself, I'm going to nominate myself for sainthood. I've lived in Dallas for 42 years and I've never had a single one. But in looking at these data, everything that we see on this slide are properties that had one or more calls. Is that correct?
Yes.
So when you say 2.07 311 calls or 3.12 911 calls per STR, that means per STR that someone has called about at least once.
Yes, or non-STR. And again, the most of the sample has no calls.
But you're not saying that the average STR in Dallas has, let's just take 911, 3.12 911 calls.
I'm sorry, can you repeat that?
I said, you're not saying that the average STR in Dallas has 3.12 911 calls.
So it's not the average because 88% of the sample doesn't generate any calls. So of those that generate calls, that's the average.
Right. So, okay. So when the headings say calls per property, what that means is calls per property that had one or more calls.
Yes.
Okay. If we take the 246, oh, wait a minute. This is a little different data. The 800, I think I was going off the May data, but the STR calls were, 836? Am I adding that up right? Out of 2,628 STRs?
I believe you're adding it right.
Is that right?
Are you asking me to check that
Well,
out?
all right, let's go, no, we go with the distinct properties. Now let's go with the total calls. There are 836 calls for STRs.
Okay, so you're adding 352 and 44.
Right, I'm adding 911 and 311.
Okay.
So let's go with distinct properties. 325 STRs had one or more calls during the study period.
Correct, sorry.
Okay, out of 2,628 STRs.
Correct.
That's an average of about, what, 325 divided by 2,628 is maybe 12 or 13%?
I don't have that answer for you today. I'm happy to bring that back.
Well, I mean, it's just math. There are 325 shown on this slide as having properties as having one or more calls. And you told us that there are 2,628 STRs. So 325 divided by 2,628 is 12, 13, 14%, something like that. 12.37, thank you very much. So 12.37% of STRs have a 911 or 311 call each year.
Correct.
Okay, if we do the same math for the non-STR properties, we have, let's just call it 16,000 round numbers of properties that have one or more calls.
I'm sorry, one more time.
Okay, we have roughly 16,000 plus non-STR properties that have one or more calls.
Okay, correct.
Okay, out of 300,000 roughly non-STR properties.
Correct.
That's 5-point-something%.
Correct.
Okay. Non-STRs, 5%, STRs, 12.37%. Thank you, Mr. Chair.
Commissioner Gracie.
Thank you. Just wanted to follow up on a question that Commissioner Kingston asked. For these calls, they do not include, and like Commissioner Treadway, fairly new, so I tried to read as many of those emails as I could, and there were a lot of emails about, guns and things like that. And am I to understand that those type of calls would not be included on this report?
That is correct.
Got it. Okay. And then the second question, first of all, I love data, so I just have to say that. Secondly, so how many of these properties, I understand most of the properties listed in this particular report have had 2 or more or 1 or more? And
Most of the properties have had 0 calls, both STRs and non-STRs.
okay, but for those calls that you listed here, that represents 1 or more calls?
Yes.
Okay. And then, so how many of them, were you able to kind of narrow that down to say, okay, of the 2,000 or so properties that you identified, how many of those short-term rental properties have, I don't know, more than 5 calls? To try and, or in other words, did you try and identify of that 2,000, some of those more problematic rentals, and where would I find that?
So I don't have those numbers in front of me, but 123 of the properties, about 4.6% of the sample, had 2 or more calls. There were a much smaller number that had much more calls. You can see that in the histogram. There were a couple properties that had 30 plus calls in the sample.
Okay.
And I'd have to get you those numbers if you want them.
Okay, and then I guess that would be a question, say, for code later, just for clarity, in terms of those 30, what was done to address those? All right, thank you.
Thank you. Commissioner Hampton.
The majority of my questions have been answered, so I'll thank my fellow commissioners and Dr. Anduchek. Thank you for being with us here today. One question I just did want to ask, I don't think it's in your data set, I don't remember seeing it, but is there any evaluation of how many of the properties are whole home versus single rooms or smaller scale? Was that anything that was included in your data set?
I think we don't have that now.
Okay, thank you. I hadn't seen it. I just wanted to double check and make sure I hadn't overlooked that. And then I guess just, I think the question about the data sets has already been answered. Thank you, Mr. Chair.
Thank you. You see what it's like, speaking last, all the questions get asked. So one more, Commissioner Rubin, please.
Yeah, thank you, Dr. Anderchuk, and your colleagues for taking the time to come today, especially since you're supposed to be on vacation. Just to drill down a little bit more, y'all use Muni Res for the sole reason that it had addresses and the other sources like Inside, Airbnb, or whatever those other sources didn't have. Did you evaluate the quality of those other sources, setting aside the fact that they didn't provide address data?
So we pulled one of them and looked at them to see if it did have address data, to see if we could get at that delta. And we looked at some factors. We found some duplicates, we found some outside the city limits, but all of that is inherent in the way that we're trying to get this data. If you need this data, what do? You go and you attempt to web scrape and figure out how many are being put out there. The problem is listings go out multiple times. So there wasn't an address for us to use, and we had concerns about some of the duplicates and some of those that were outside the city limits.
One other question. You mentioned you have to web scrape, but most of these STRs operate through a platform, be it Airbnb, Vrbo, et cetera, et cetera. Did the platforms ever provide data on their listings that would have allowed you to study this?
My understanding is no. I would have to turn that question over to those that have dealt with the platform, but we have never received any information from the platforms to allow us to do that.
Okay. And, looking at this number of these 2,000, 2,500 that MuniRevs did pull, was there any attempt to sort of cross-validate this with what DPD has seen to see if there are any, problem STRs that didn't make it into the MuniRevs list?
Sort of. So mostly no, but the one thing that was done early on in 2021 is we did pull a list of nuisance properties that other agencies in the city were working on, and we did kind of cross-reference those to see if we had missed things. And so we found that there were a number of properties, non-STR and STR, that were on that list of properties.
And did you get a sense of how many STR properties weren't on the MuniRevs list that were nuisance properties?
So not that were identified as STRs, because those nuisance properties at the time were not identified as we think this is an STR. Of that list that we had them, especially those top, if you're having parties all the time and you're getting 30 calls and we know where you are, we pretty much knew right to go figure out if those are STRs. It took a while to get down the list to get to the first STR. There were many problem properties that were on the list, is my recollection.
Okay. Thank you so much.
Commissioner Hampton, please.
Thank you. I did have one final follow-up. I think we've been talking generally about the numbers. You kind of have aggregated the calls. You've aggregated our total number of properties that you utilized in your data set. Was there any evaluation? I mean, I think, from the map that you have and the map that we have on where STRs are distributed, they're not equally distributed. Was there any evaluation of sort of where they're concentrated, where STRs are concentrated versus their calls?
No, not more than putting them on that map.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Commissioner Kingston, please.
Thank you. I heard you say that you relied on UniRevs because that is the vendor that has addresses, and it is also the vendor that the city has a contract with. Is that correct?
It is the source, yes.
Okay. And then I heard you say a moment ago that you only looked at one of the other potential sources and were unable to find addresses within that source. What source was that you looked at?
Inside Airbnb.
Okay. Are you aware that AirDNA has addresses and you can obtain those from AirDNA?
I am not aware of AirDNA.
Okay. So of the other sources, you guys really didn't look at all of them to determine whether there was a more reliable source for your data?
We know that we have addresses. We know that we could validate them, and it's the city's official source. So we would have been hard-pressed to explain why we weren't using the city's official source.
Might be hard-pressed to explain why that is our official source.
But that's
Thanks.
Thank you so much.
We have one more question. Commissioner Hawk, did I hear you?
I've got a question.
I had one. Commissioner Popkin has a question.
My apologies, Commissioner Popkin, please.
Yes, just quickly, I was referencing your interactive map of the nuisance calls and noticed that they were divided by use category between planned development, single family, and cluster housing zoning category. I was under the impression that we had no cluster housing developments within the city. I'm curious what those are exactly, because it's a sizable amount. It looks like there's as many STRs getting nuisance calls in cluster housing as there are in single family, which is curious to me.
I can work to get you that answer. We were asked to provide those overlays and put them on there because it was of interest to the council members.
Yeah, it absolutely is. In the types of areas that we're seeing nuisance properties across the city, especially if we're looking at different zoning categories and trying to regulate accordingly, that would be really helpful if you could provide that by this afternoon, perhaps.
We can do that.
Thank you very much. Thank you, Mr. Chair.
Thank you. Vice Chair Rubin.
Just a couple quick follow-up questions on the data source. Did the city contract with MuniRevs specifically for this study, or does the city have a larger contract with MuniRevs to get data for various analytics?
My understanding, and I'm not the city controller who owns that contract, is that they are contracted with them to collect the hot taxes, and that is their primary purpose.
Okay, thanks.
Commissioner Standard.
Very quick, because I know you're in a hurry. I just would like to have some acknowledgement again about the limitations of a study. This is the registration right now, because we don't have an ordinance in place, is sort of a voluntary thing. Is that correct? As far as you know?
As far as I know, and I'm not the person to speak about ordinance.
But what I'm getting to, so there is a limitation in this whole identification of how many STRs, how many not, how many, et cetera, because we're relying on people before we have an ordinance voluntarily signing up to pay the hot tax. So it makes it sort of like nebulous. We're not quite sure how many, you know, who's in, who's out, et cetera. I just want to say that that is a limitation, correct?
Absolutely. So every data project has its limitations. We use the best data we have to attempt to answer the question. The biggest limitation in this study, which is listed, is that we're making assumptions that those homes were in use as STRs at the time.
Correct.
So we acknowledge that there are limitations, and if someone
Right.
doesn't call, they don't call.
And there could potentially be a lot more that have never registered for a hot tax.
Yes.
Okay, thank you.
Thank you, Commissioner. Please, Commissioner Gracie.
I'm sorry, Brenda. One more question. sort of. So I was talking with Buddy Lance, Controller's Office, and just trying to understand the correlation, right? So on one hand, short-term rentals, there's an opportunity to collect revenue and through the hot tax, right? And to Commissioner Kingston's point, typically when you hire, going back to my procurement days, when you contract with a firm, you typically contract and they guarantee from a revenue, I believe this is a revenue contract, so they guarantee how much they are able to collect. With that said, I'm trying to understand, just grasping, and I get the differences between the numbers, between, you know, MuniRevs and the other three that have been listed, but for the ones that have addresses, has MuniRevs, to your knowledge, or Lance, to your knowledge, made any effort to reconcile that difference in order to collect more revenue? Yeah, I'll stop right there.
I'm happy to let Assistant City Controller Lance Seahorn answer that question.
Okay. Yeah, they, my name is Lance Seahorn, I'm the Assistant City Controller. So MuniRevs has not attempted to reconcile their data with another source of data. Is that what you're, if
Yes.
that's what you're asking
Yes,
for?
sir.
No, because we haven't received any other data with addresses that they could reconcile to. So I know Sherry, the city controller, is working with Mr. Estelle on trying to reconcile some of the data between MuniRevs. It's now called GovOS. GovOS bought MuniRevs, so we really should be saying GovOS now, it's rather than MuniRevs. But so the city controller, Sherry Kowalski, has been working with Greg Estelle with some of his data. So they've just recently started working together on trying to reconcile the data, and that's all the information I have on that.
Okay, okay. And then the last question I'm going to ask is kind of the combination of the both of you, and I know it hasn't been done, but I'm wondering if it can be done. We know that I think you said in 2019 had 600,000 of hot tax from short-term rentals in 2019, yes. And then in 2022 jumped to about 2.6 million or so.
Yes.
Does that correlate with that growth from 2019? And I think you only did 2022, Dr. Anderchek, you correct me if I'm wrong, just that March to March timeframe, right? In this particular study. Does that, I guess I'm trying to figure out, is there a way to align the amount of revenue collected with your number of short-term rentals that have been identified? And I understand it's based on, square footage and things like that, so that dollar amount can vary, but has there been any, or is there a way to reconcile that to ensure that you have identified all of the correct properties? And I'm asking either one of y'all. Do you understand what I'm asking?
I'm not fully understanding what you're asking.
So we collected 2.6 million in 22, it's 2.6 million in hot tax in 2022.
Yes.
At that point in time. Is there a way to see if does that align with the 2,000 or so short-term rental properties that you identified in this study?
So let me just clarify. So us identifying them is pulling them from the MuniRes system. So they would be already sort of lined up.
Oh, got it. Okay.
With that. Does that make sense?
Yes, it does.
Is that
It
your
does.
question?
Yep, that
Okay.
is it. Thank you. All right, that's all I have. Thank you.
Thank you. Any other questions, Commissioners? Thank you very much, Dr. Andrzejczyk, to you and your team. Thank you for coming in. Ladies and gentlemen, that concludes the briefing of the Dallas City Plan Commission. It is 12:33 p.m. Commissioners, the goal is to take a quick lunch. We must be back, and the hearing must begin before 1 o'clock, so don't go too far. We'll be back in about 20, 25 minutes.